Just waiting for a few people to come in. We're going to be looking at the FOIA, the FOIA, again today for about an hour. Bull, bull. I hear you, Drakey. New info. Gypsy Rose Blanchard and Nick Godejohn FOIA. How about reading full FOIA? There we go. That works for me. Hey, Lindsay. How are you? How are you? How's everyone doing tonight? I'm just ordering. I'm ordering some Taco Bell, y'all. We're gonna be reading the FOIA for about an hour because I have a really good video coming out for you guys. Hey, Rat Squid, how are you? How are you doing? We're reading over the FOIA from Nick and Gypsy today. We read some of it yesterday. So, yeah, we're doing the damn thing today. We're going to be here for about an hour. About an hour. I'm okay, Lindsay. I'm okay. I think I'm going to, I tried to get some sleep last night, but still didn't get a lot of sleep. So I'm going to have to take matters into my own hands at this point, Painting your nails, that sounds fun. That sounds good. Put on my lip gloss because I don't know where my Carmex went. And I do have some water because I'm going to be reading. Where we left off yesterday, we were talking about Nick's defense. And we were talking about if we think that Nick can have a diminished capacity defense. We were reading the information from, his counsel saying that his lawyers didn't get the right type of doctor for him to explain his disorder to the court appropriately. And we're going to go in on that a little bit more. On the first day, we got through about 77 pages of the FOIA. I'm going to pull it up for you guys a little bit bigger. Hopefully I can zoom. I think I can zoom. I'm going to zoom for you guys so you guys can actually see. Because yesterday I was like, that's kind of like, I didn't like it. Okay, let's see. I will have to pull it over here. Okay, so I'm going to be reading. I'm going to stop and we're going to talk. If you guys are just joining, make sure to hit that like button, hit that subscribe button. I'm going to be reading. In front of me, then have it up here. And this monitor is not plugged in, so we got a lot of moving parts. I will have a video coming out on the Behind the Cult series after this live stream. I still have to tweak it in a few little places, so wait for a video drop tonight. But let's get into this, okay? Okay, so here it says, let's get our highlighter. To be admissible in surrebuttal, evidence must be relevant and otherwise admissible. State versus Taylor. Much of the testimony of Dr. Denny's rebuttal testimony regarding autism spectrum disorders was at the very least misleading and oftentimes incorrect. An expert who had substantial practical evidence experience in evaluating and treating individuals with autism spectrum disorders, such as Dr. Ted Wasserman, would have been able to testify in rebuttal to Dr. Denny's misrepresentation of autism and Asperger's disorder. When asked by the prosecutor to explain why he agreed with Mr. Godejohn's historical diagnosis of Asperger's syndrome, Dr. Denny testified as follows. He says, "Well, yes, I can. And to be fair, if we can't just say that because his history started out with autism when he was younger. Because one of the things that would classify a condition as autism for young children is not only the communication problem and the preservative kind of rogue behaviors, collecting things, playing with things in an odd way, repetitive behaviors." Okay. Let me just highlight this. My highlighting is bad, but you get the point. But also delay in language functioning or general cognitive functioning. If the person had those delays as well, then it will be considered autism. Okay. Language functioning, general cognitive functioning. If they did not have the language delays or overwhelming cognitive delays, then it was considered Asperger's. Okay, so that's the key difference here. And back then, when Mr. Godejohn was very young, there were indications of delayed language functioning at young ages, and so he was diagnosed with autism. Then once he reached high school, those areas caught up, so they were no longer relevant to his condition per se, and they fell away, which then changed the classification over to Asperger's, changed the diagnosis to Asperger's for him. And we don't know exactly why there was that delay there. It could have been a delay but either way, he caught up, and so it was Asperger's. And I agree with the diagnosis at the time. I think it was correct. Okay. So what they're saying is autism has, what this doctor is saying, Dr. Denny is saying, autism to him has as delay of language functioning and general cognitive functioning. I've always been told it's a spectrum, so I don't know. This seems a little extreme, okay? But he says he thinks that is correct. A qualified expert such as Dr. Wasserman would have been able to testify that Dr. Denny's description of the language development and functioning of an individual formerly diagnosed with Asperger's disorder is incorrect. There are early delays that self-correct, but adult language is truncated in several aspects. In addition, there is extant research which clearly demonstrates there are real differences I can say neuropsychologist, but neuropsychologically between autism and Asperger's disorder. In addition, Dr. Denny concluded that Nicholas was mildly autistic. He testified that Asperger's was a very mild form of autism. Dr. Denny also testified that his diagnosis of Nicholas Godejohn was autism spectrum disorder or mild or level 1. Dr. Denny's testimony that Nicholas Godejohn was mildly autistic is misleading, and his insinuation that autism level 1 is mild autism is actually incorrect. What's mildly autistic? I don't know. I've never heard of that before. An expert who has substantial practical experience in evaluating and treating individuals with autism spectrum disorders would have testified on rebuttal that what Dr. Denny is terming as mild merely reflects the superficial socialness of an individual with Asperger's disorder that masks ongoing significant social dysfunction. The superficial socialness that masks ongoing significant social dysfunction. That's what he sees. Okay. Dr. Denny appeared to use the word mild in a manner consistent with colloquial usage, meaning not severe, serious, or harsh, which implies to a layperson that autism was hardly a factor at all and could be discounted. In fact, he used some version of the term over a dozen times during his testimony. A qualified expert would have pointed out on rebuttal that was a gross mischaracterization of the term mild when used in conjunction with autism for descriptive purposes. Okay, so from what I'm getting, if you guys are just joining, make sure to hit that like button. What I'm getting from what he's saying so far, what the attorney's saying so far here, is that the doctor for the the doctor for the state tried to downplay Nicholas's condition. From what I'm reading, they describe it as mild autism or mildly autistic, and that Asperger's is a mild form of autism. I don't know if I've ever heard that, because in certain cases, the Asperger's can be severe. In certain cases, Asperger's can be very severe. So for him to say that Asperger's is a mild form of autism, I don't know exactly what he's trying to say. Basically what I get from that piece of information is, if you are verbal, if you can speak, then you are mildly autistic. I might be pushing it a little bit there. I might be drawing a little bit there, but that's what I'm getting from him. If you show any sign of social activity, then you could not be autistic. I don't know how old the doctor is. I don't know where they come from, but that is what his defense is trying to say here. If you're just joining, make sure to hit that like button. We're going to continue to read. This is Nick and Gypsy's FOIA. Okay. And we're at the top of page 79. Despite the severity of symptoms, individuals with autism always have the same core deficits. There are strong and consistent commonalities in social deficits that result in individuals with ASD interacting with others differently. A qualified expert with practical experience in evaluating and treating individuals with autism spectrum disorders would have testified on rebuttal that certain symptoms must be present in order to qualify for a diagnosis of autism spectrum disorder. Even people with level 1 autism may have significant developmental and sensory challenges. Okay, sure. Even people with level 1 autism may have significant developmental and sensory challenges that are severe enough to get in the way of normal activities and relationships. Therefore, individuals suffering from high functioning autism, by definition, are impaired in understanding social cues and responding to them. Okay. So the argument, I feel like the biggest part here, the argument is, should they have had a doctor that specialized in autism spectrum disorder on the case specifically? Or does any doctor suffice for this case? Does any doctor have enough information about this disorder to be able to render an expert opinion on Nicholas's mind state at the time? That's where the argument's coming from. A qualified expert with practical experience in evaluating and treating individuals with autism spectrum disorders would have also testified in rebuttal that any person meeting the criteria for having ASD will be further diagnosed as having ASD level 1, ASD level 2, or ASD level 3. These levels specifically indicate how much support an autistic person needs, with level 1 meaning relatively little support is required, and level 3 indicating the need for a great deal of support. Nowhere in the DSM-5 is the word mild used in describing Asperger's disorder or ASD level 1. And I can agree from the person that I knew that had Asperger's. She could be, I guess you could say, she could have her good days, but there were days that were not mild, and you can tell that that was this disorder taking a hold of her. So that's just my personal opinion in seeing it. A qualified expert, we're here, a qualified expert with substantial practical experience in evaluating and treating individuals with autism, would have been able to testify in some rebuttal that Nicholas Godejohn did not get the level of support he needed at home or in the form of services in the community. A qualified expert would have testified in some rebuttal that this is evidenced by Nicholas Godejohn's Social Security disability records. Less than 7 months prior to the offense, Nicholas's mother, Stephanie Goldammer, completed a Social Security benefits form in regard to Nicholas's disability titled Social Function Report, Adult Third Party. In this report, Stephanie writes that Nicholas has a lot of concentration problems, is not comfortable around people, sometimes seems to have problems grasping the real world. She reports that Nicholas doesn't understand why you need to take a shower, why you clean your room. Nicholas's mother also reports that Nicholas is not capable of cooking an oven-prepared meal. Stephanie Goldammer also reports on the form that the computer is a lot of his connection to people. He is always to himself. In addition, the prosecutor asked Dr. Denny if he had published a paper in regards to autism, and he responded, "Yes, I have." This one paper is also listed in Dr. Denny's curriculum vitae, which was also put into evidence at trial as State's Exhibit 187. The paper is entitled An Estimate of the Prevalence of ASD in an Incarcerated Population. And the primary author is listed as Rachel L. Fazio. The secondary author is Christina Peets, and Dr. Robert Denny is listed last, and the published date is listed as 2012. The School of Professional Psychology at the Forrest Institute is also referenced in the author section. In 2012, Dr. Denny was a professor at the Forrest Institute and also supervised doctoral students. A qualified expert with substantial practical experience in evaluating and treating individuals with autism spectrum disorders could have testified in rebuttal that the fact that Dr. Denny's name is third line on this particular research paper does not make him an expert in the area of autism spectrum disorders. Okay, so they're saying that he has written a paper on autism spectrum disorder or co-authored a paper on autism spectrum disorder. So that should show his competence to be on this case. But the name of the paper is An Estimate of the Prevalence of ASD in an Incarcerated Population. That doesn't really dig into the nitty-gritty of what ASD is. It just tells you how prevalent it is in an incarcerated population, right? I mean, I guess it could have some ties if you're looking at ASD and crime and criminality, sure. But does it really dig deep into, Asperger's or anything? We really don't know. Okay. Hey, Bree. If you guys are just joining, make sure to go ahead and hit that like button. We are reading the FOIA, and they're going into the state's doctor and talking about how they feel as if he is not qualified, guys. He's not qualified to speak on Nick's condition. Give me 1 second, guys. Yep. So Lindsay's in agreement that the doctor should not be on this case. They're saying, yeah, he's an expert. I don't know. I don't know personally. Personally. Okay, let's continue. If counsel would have adequately investigated, let me get a little water. Got to refuel after every couple of pages. If counsel would have adequately investigated a diminished capacity defense with a qualified, experienced expert who had substantial practical experience in elevating and treating individuals with ASD to determine whether Nicholas Godejohn suffered from a mental illness, disease, or defect at the time of the offense, which precluded him from deliberating, counsel would have discovered that an expert such as Dr. Ted Wasserman, they keep bringing this guy up. Is this like their friend on the job? Why? Why is Dr. Ted Wasserman the best guy for the job? Because he's the only specialist in the state? Like, where are y'all pulling him from? I don't know. Was available and would have concluded to a reasonable degree of psychological certainty that, number one, Nicholas Godejohn suffered from a mental disease or defect at the time of the offense, and two, due to his disorder, Mr. Godejohn was not capable of deliberating or of cool reflection at the time of the crime. Dr. Wasserman or a similarly situated neuropsychologist would have testified at the guilt phase of Mr. Godejohn's trial and will testify at any hearing granted in this case that because of his ASD, Mr. Godejohn's ability to deliberate at the time of the offense was non-existent, and therefore, Mr. Godejohn did not have the ability to deliberate at the time of the offense. Counsel's ineffectiveness resulted in prejudice to Mr. Godejohn, and that counsel's failure to investigate and present evidence from a qualified neuropsychologist specializing in ASD allowed the prosecutor to argue in closing that Gypsy did not manipulate Nick into doing this. The jury, hold on a second. The jury did not hear evidence about how Nick's autism played a role in his relationship with Gypsy. Without this evidence being presented from an expert with a substantial practical experience in evaluating and treating individuals with ASD, the state was able to make the following closing argument without any contrary evidence being presented by the defense. And absolutely, you heard, as part of the facts, Gypsy did have a role. She was the one to ask the defendant to unalive her mom. But we have to be careful and separate what is collaboration versus manipulation. Because there could be this sense that because Gypsy was the one that asked the defendant, somehow she manipulated the defendant into unaliving her mom. Let's think about that for a minute. Think about manipulation. It requires some type of deception. I want to steal a car, so I tell you, hey, see that car over there? The owner said I could have it. It's okay. Could you just go get it for me? That's manipulation because we're deceiving versus, hey, that car over there, I want to steal it. Do you want to do it for me? That's not manipulation. She asked him, but he said yes. And if you think about it in a way, Gypsy asked in the least manipulative way because she didn't lie at all. She put it all out there. She didn't try to do it through innuendo. She didn't make up things. She just said, this is what's happening to me. Will you unalive my mom? There's no manipulation there because ultimately it was the defendant's decision. Nothing was held back from him. And if anything was evident from the dynamic of their relationship, that you saw in the Facebook, in the text messages, in the interview, and in Gypsy's testimony, Nicholas Godejohn was not made to ever do anything Nicholas Godejohn did not want to do. Counsel was ineffective for failing to investigate and present evidence from a qualified, goodness, they keep saying this, like we get it, okay? From a qualified neuropsychologist specializing in autism spectrum disorder to support a diminished capacity defense at trial during the guilt phase. Nicholas Godejohn was prejudiced by counsel's failure in that the outcome of his trial would have been different, and Mr. Godejohn would not have been convicted of unaliving in the first degree. A new trial must be ordered. Okay. Hey, Jay. If you guys are just joining us, make sure to hit that like button. Hi, Jay. Sorry, guys. I'm bobbing in and out. If I don't respond immediately, I'm reading the pages. Rat Squid says, my nephew has autism, and I can see the similarities between Nick and him. It breaks my heart how the justice system failed Nick. It breaks her heart. And she doesn't agree with what Nick did, but she says it was clearly biased. Make sure you guys like the stream. Thank you so much. Okay. Sorry, guys. I'm trying to get my Taco Bell ordered and on the way. All right. So let's continue. Okay. So 8 is ineffective assistance of counsel, failure to investigate and present evidence from lay witnesses in guilt phase to support a diminished capacity defense. And they go on to say, Nicholas Godejohn was denied effective assistance of counsel, a fair trial, due process, and was subjected to cruel and unusual punishment in violation of his rights under the 5th, 6th, 8th, and 14th Amendments to the United States Constitution and Article 1, 10, 1821 of the Missouri Constitution, in that his trial counsel failed to fully investigate and present evidence from family members and others to support a diminished capacity defense. Counsel failed to exercise the customary skill and diligence that a reasonably competent attorney would have exercised under similar circumstances. Nicholas Godejohn was prejudiced as a result, and that had counsel had not been effective, there is a reasonable probability that he would have not been convicted of these crimes, and he would have not been sentenced to life without probation and parole and 25 years. Counsel was aware, or should have been aware prior to trial, that Nicholas was diagnosed with autism as early as 2nd grade and with Asperger's syndrome in high school. Counsel was aware, or should have been aware, that ASD refers to a group of complex neurodevelopment disorders characterized by repetitive and characteristic patterns of behaviors and difficulties with social communication and interaction. Okay, that is ASD right here. That's the definition. Counsel was aware, or should have been aware, that the symptoms of ASD are present from early childhood and they affect daily functioning. Sorry, y'all. Counsel was aware, or should have been aware, that there are structural brain differences in someone with ASD compared to those without ASD. Knowing this information, counsel had a duty to retain a competent, qualified expert with substantial practical experience in evaluating and treating individuals with ASD, such as Dr. Theodore Wasserman, to investigate mitigation evidence on how Mr. Godejohn's autism, his chaotic upbringing, and the facts of the case were mitigating. Counsel's failure to do so fell below the standard of care that a reasonably competent attorney would exercise in similar circumstances. Had counsel hired the appropriate type of expert, they keep repeating this like it's annoying, a neuropsychologist with substantial practical experience. Like, did you guys need to hit a word count? And evaluating and treating individuals with ASD, such as Dr. Ted Wasserman, you just said that, counsel would have known that individuals with ASD are extremely susceptible to social manipulation and suggestion by virtue. That does not mean just because individuals with ASD are extremely susceptible to social manipulation, that does not mean that they can get away with what Nick did. That doesn't mean that, because what happens when it happens again? You see what I'm saying? Just because they're extremely susceptible to social manipulation, we can't give a free pass for that kind of behavior. They have a greater need for emotional intimacy, both romantic and otherwise, the fragile nature of their developing relationships, social impairment, empathy imbalance, deficit of cognitive empathy, which is being able to understand and predict others' mental state, but a surplus of emotional empathy, which is the capacity for attachment, and hyper focus on a narrow range of interests. An expert neuropsychologist specializing in ASD would have explained to trial counsel how these recognized and accepted characteristics combined with Nicholas's all-encompassing relationship with Gypsy Blanchard over a 2.5-year period affected Nicholas's actions at the time of the offense. Okay, we talked about Dr. Wasserman. They would have informed counsel that you could not separate Nick from his autism. He's always autistic. Okay. So the court papers say that she did not manipulate. Sorry. The closing argument, Lisa, says that the state's lawyers say that. They said that Nick didn't do anything that he didn't want to do, in saying that Nick made the conscious decision to do this to Dee Dee. So it was not manipulative. It was not manipulative because Gypsy just straight up asked him. She didn't try to pull a bait and switch. She just asked him and he obliged. So the state are the ones that are saying that. Hi, Shauna. Hi, Lisa. If you guys are just coming in, make sure to hit that like button. We are continuing to read the FOIA. Today, we're kind of a little bit more on the diminished capacity defense. We're a little bit still on the idea that Nick's defense did not have the right experts for the trial. That's what they're trying to say. They're trying to say if they would have had someone like Dr. Ted Wasserman, who specializes in this stuff, and they keep repeating it. Like, I'm not going to continuously read it when they repeat it. Like, girl, what's going on? Like, why do y'all keep repeating that? I think my food's here. Whenever they say Dr. Wasserman, we're skipping it, okay? Okay. Further informed trial counsel that Nicholas's autism combined with Gypsy's request of him and her planning resulted in Nicholas surrendering his deliberation to Gypsy by taking what she has said as fact. You know, doing this is the only way we can be together. It's up to him to save her. The defense, they're saying that Nicholas surrendered to Gypsy's logic. Dr. Wasserman, or similarly, okay, they're saying a better doctor would have informed counsel that these are the characteristics of an autistic person. Hang on one second. I'm going to go grab my food. I'm going to leave this up. So my food is here. So I'm going to take a short little break. And when I say short little, I mean like 10 minutes or so. Maybe not that long. I got Taco Bell, y'all. So if you guys don't like seeing people eat, I'm sorry. Mmm. Mmm. It's good. Mm-hmm. These are those little churros. They're so tasty. Mmm. Hey, Jalen. But I have a question for you guys. Do you believe that Nick has a diminished capacity? Let's get that conversation going. I'm going to eat one of these and I'll be right back and we'll read. I'm going to just eat one. I'm still here. Sorry, y'all. I was hungry. I am hungry as hell. Sorry. I'm going to continue reading. I see what y'all are saying. I think we're all on the same page that the diminished capacity defense was not going to work in this case. If you're just joining, hit that thumbs up button. Let's continue. Okay. Further mitigation evidence, in addition to the opinions of an expert such as Dr. Wasserman, was available to counsel through information from Nicholas Godejohn's family. One second. About his behavior over the course of his entire life, as well as over the time period he was involved in an online relationship with Gypsy Blanchard. In addition to interviewing family, this information could have been obtained from school records, hospital records, Social Security, disability records, videos on Facebook, messages, videos and Facebook messages provided in discovery, and Nicholas's records, including his mental health records from the jail in Wisconsin. Information on Nicholas Godejohn's family in Wisconsin would have provided anecdotal information about Nicholas's behavior relative to his autism, family history information, and mitigating information about Nicholas's upbringing and his relationship with family members and his lack of relationships with others. If counsel would have requested and received Nicholas Godejohn's county jail records, including his jail mental health records, counsel would have known that when Nick was in jail, he was visited by several family, and they also should have been aware of the fact that 3 years prior to the defense, Nicholas Godejohn and Gypsy engaged in an increasingly intense online relationship, which include sexually explicit online chats and videos made by Gypsy and sent to Nicholas. So was this ever the other way around? Did Nick ever make her any, or was it all Gypsy making these videos? You can't tell me that she was not excited or interested if she made each and every last video. If it was his thing, I'm pretty sure he would have made a video or two. She was into it, you know? Counsel elected to put forth a diminished capacity defense at trial. Counsel hired a neuropsychologist in anticipation of presenting evidence to the jury of Mr. Godejohn's inability to deliberate at the time of the offense. Once that decision was made, counsel had a duty to investigate and gather information from family members and other lay witnesses who observed Mr. Godejohn's behavior throughout his life. Counsel had a further obligation to then call those witnesses to testify at trial, to present evidence to the jury that would have supported a diminished capacity defense. Counsel's failure to do so fell below the standard of care that a reasonably competent attorney would exercise in similar circumstances. Evidence that the defendant did or did not suffer from a mental disease or defect is admissible in a criminal prosecution to prove that the defendant did or did not have a state of mind, which is an element of the offense. This is commonly known as the defense of diminished capacity. Okay. This is it right here. When first recognizing the diminished capacity defense, the Missouri Supreme Court defined it as proof of mental derangement short of insanity as evidence of lack of deliberation or premeditated design. In other words, it contemplates full responsibility, not partial, but only for the crime actually committed. And then they talk about some other court cases. They talk about walk up. We talked about this yesterday. We read this exact same thing yesterday. Okay. The walk-up trial is when the guy unalived his girlfriend. They're saying that he suffered from bipolar during the time of the offense, and that was logically and legally relevant to the issue of whether the jury should believe the state's evidence that he acted with deliberation. The walk-up court also held that the notice provisions of Section 552 did not apply to diminished capacity evidence under Section 552. For purposes of a diminished capacity defense, the terms mental disease or defect include congenital and traumatic mental conditions as well as disease. They're saying information from Nick's family about his behavior over the course of his life would have supplemented the testimony from an expert and would have provided anecdotal information to the jury, which would have supported the defense theory of diminished capacity. Counsel's failure to investigate and present witness from Nicholas's family and other lay witness was ineffective and resulted in prejudice. A new trial must be ordered. So they're saying that Nick's lawyers, so they both sent videos to each other. That's what I thought. That's what I was thinking. But yeah, the videos that Gypsy sent, there was like over 100. I'm pretty sure they explain them in this FOIA. But Nick sent her some, but she sent way more. So it was a back and forth thing. So I don't like how at Nick's trial, the state tried to make it seem as if this was his thing, when obviously Gypsy was a very well and willing participant in this, right? So excuse me. We have ineffective assistance of counsel, failure to investigate and present mitigation for use in plea negotiations. Okay. We read this. So they think that Nick was denied effective assistance of counsel, a fair trial, due process, and equal protection of the law. And he was subjected to cruel and unusual punishment. That's what they're saying. His representation in court. He didn't get a fair trial. He didn't get due process. He didn't get equal protection of the law. He got nothing that he should have gotten under his constitutional rights. They say that his defense counsel rendered ineffective assistance of counsel by failing to investigate mitigation evidence for use in plea negotiations. Counsel failed to exercise the customary skill and diligence that a reasonably competent attorney would have exercised under similar circumstances. Okay. They're saying the failure of his attorney, his representation's failure, led to Nick being denied a fair trial, due process, and freedom from cruel and unusual punishment. It may be a stretch. It may be a stretch. This may be a stretch. But I see where they're going with it. If you guys are just popping in, make sure to hit that like button. Defendants have a Sixth Amendment right to counsel, a right that extends to the plea bargaining contest. I'm sorry, y'all. I'm locked in on this. Hang on a second. So, in the Sixth Amendment, you have the right to counsel, and that extends to the plea bargaining process. During plea negotiations, defendants are entitled to effective assistance of competent counsel. In a court case that happened, the Supreme Court plainly recognized that plea negotiations are a critical point in the course of a criminal proceeding in which effective assistance of counsel is required. I agree. Like other claims of ineffective assistance of counsel, claims of ineffective assistance of counsel arising from plea negotiations are reviewed under the two-part test laid out in Strickland versus Washington, United States versus Regnos, and Hill versus Lockhart. Okay. A letter in the trial file from Mr. Godejohn to trial counsel dated September 13th, 2016 reads in part as follows. So this is a letter from Nick to trial counsel, to the lawyers. Today, when we were in court, you told me that the prosecutor was not interested in this time today when we were in court, you told me that the prosecutor was not interested at this time in any plea agreement. What I would like to know is exactly how that conversation went, as close as you can recall, just so I understand in my mind where he is coming from. If there is a possibility that in the future this may be something he would consider, I would like to know if this means it is still an option or possibility. Okay. The trial file reflects that counsel engaged in plea negotiations with the prosecutor on at least two occasions. A memo in the trial file reflects that trial counsel conveyed to Mr. Godejohn on December 2nd, 2016, the state's first offer of life with parole eligibility on a plea to unaliving in the second degree with the dismissal of the armed criminal action charge. The memo states that Mr. Godejohn rejected that offer, but did want counsel to make a counter offer of 15 years or a reduced charge of unaliving in the second degree and 15 years on the armed criminal action to run concurrent. The state made a second plea offer to Mr. Godejohn on March 2nd, 2018. This offer was for life, no probation, but he could get parole on a charge of unaliving in the second degree with 10 years. I don't get that. Consecutive. I had to continue reading. Consecutive on the armed criminal action charge. This offer was rejected by Mr. Godejohn on May 2nd. So they offered him two pleas. The first one, life with the possibility of parole. The second one, life with the possibility of parole and 10 years for armed criminal action. And both were denied. Both were denied. Nick denied both plea deals. So can we really, really truthfully say anything? Can we say anything? Because he was giving two plea deals and he didn't take either one. He wanted to take it to trial and they were not prepared to take this to trial. And the lawyers didn't care what happened after the trial. That was obvious. But it's probably clear or important to note that Nick didn't know this. It is clear that Mr. Godejohn was open to taking a plea deal in this case. It was incumbent then on counsel to engage in a meaningful plea negotiation with state in order to get the best plea offer possible. I mean, they got to. Because they weren't what you wanted, you didn't take them. Now you can't get out at all. You see what I'm saying? You guys see where I'm coming from with that? This is saying that his counsel should have gotten a better plea offer, like one like Gypsy got. An important aspect of plea negotiations is presenting mitigating evidence about the crime and the defendant to the state to support an argument for plea to a lesser charge with a lower sentence. Counsel failed to adequately investigate and present mitigation evidence to the prosecutor, in this case as part of plea negotiations. Counsel should have been aware that Nicholas had ASD, and they defined ASD for the 17th time. They tell us that ASD is present from early childhood and it affects daily functioning. They tell us that there are structural brain differences in someone with ASD compared to those without. Counsel was also aware, or should have been aware, that for 3 years they had this intense online relationship. They said that about 800 times now. Okay. What? Where did this page come from? There's pages missing, but we're on page 91. We did not go as fast as we did yesterday. At all. Today, we, went over the FOIA for an hour, and there was a lot of repetitiveness around what the lawyers didn't do. Moving forward, for tomorrow, I'm going to try to not, this is going to, they talk about this for a minute here. Okay. Yeah. So this is still on Nicholas's appeal and why they believe that he should get an appeal. All the reasons, yada, yada, yada. But we are on page are we on? We're on page 91. And we're going to get into more of that. But if I see anything that seems like it's repeated, because there was like a lot of repetition, like Weeds had said, there would be a lot of repetition. He did have the plea deal offer, Lindsay. He did. He didn't take it. So it seems like tomorrow it'll talk more about Gypsy and Nick's interactions, who visited Nick while he was in prison up here at the top. Nick's conversations with the therapist and people in jail, and it'll go from there. It doesn't seem like, let me just take a peek into my future. It doesn't seem like we're getting into that juicy stuff. When are we getting into that juicy stuff? Is the juicy stuff halfway down? I don't know. We'll get to the juicy stuff, but we're just reading it in its fullness. We'll come on here every day for about an hour. I don't think he knew what kind of deal she got. But I can say this. He wanted something like 15 years. He didn't want life. He probably heard life and it freaked him out. So he said no. And went to trial and got life without parole. That's what happened, y'all. That's exactly what happened. I'm not thinking they can discuss like each other's charges with the other, but I'm pretty sure he knows now, but I have to get to editing this video. I'm really excited for this video to come out on the FLDS. It'll be out tonight, later tonight, because I still have a little bit of tweaking, a little bit of twalking to do with it. I think it'll be really interesting. I want you guys to tune in. Make sure to hit that like button. Put a comment at the bottom. I really appreciate you guys coming through and reading the FOIA with me. I'll be back tomorrow to give you guys about another hour and a half of reading the FOIA. I hope you guys have a great rest of your night. Bye now.